Today, we will discuss the core legal documents that every new company requires. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am also Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. At the core of any startup or new business venture lies the essential formation documents which establish the company as a legal entity separate and distinct from its owners. These documents are not only crucial for compliance, but also serve as the bedrock for the company's structure and governance. For corporations, the operative document contains the Articles of Incorporation, also known as a Certificate of Incorporation in certain jurisdictions. This document outlines the fundamental details about the company, such as its name, address, and the number and type of shares it is authorized to issue to its owners. For startups opting for a limited liability company or LLC structure, Articles of Organization, also sometimes referred to as a Certificate of Formation, and an operating agreement are indicated. This operating agreement delineates the operational framework and management responsibilities among the LLC members. Remember, LLCs do not have shareholders, they have members, and that is a critically important distinction. While not strictly required by law, having a well-drafted operating agreement can prevent disputes and misunderstandings among principals. Protecting sensitive business information is paramount for any venture, particularly those developing proprietary assets. A non-disclosure agreement, or NDA, serves as a critical tool in the armamentarium of legal protection to safeguard proprietary information. NDAs are legal contracts that establish a confidential and enforceable relationship between the parties, obligating them to keep specific information private. These agreements are exceptionally useful when sharing business plans, ideas, or products, particularly those that are in development, with potential investors, partners, or employees. NDAs typically include definitions of exactly what constitutes confidential information, as well as what is not considered confidential information, as well as the obligations of the receiving party and the duration of confidentiality. It is critical to ensure that the NDA is tailored to fit the specific needs of the venture, as a generic NDA will likely not provide adequate protection. As startups innovate, they often create valuable intellectual property. An intellectual property assignment agreement ensures that that intellectual property developed by employees and independent contractors is legally owned by the startup. This agreement, when executed correctly, transfers rights from the creator to the venture, preventing future disputes over ownership and usage rights. Including clauses that require employees to disclose any inventions and assign them to the company can further solidify the venture's claim over its innovations. It is also wise to define the types of intellectual property covered with as much specificity as possible, such as patents, copyrights, trademarks, and trade secrets. Ensuring that these agreements are in place from the outset can save significant legal headaches in the future. Clear and comprehensive employment agreements for non-at-will employees and carefully drafted offer letters for at-will employees are useful for delineating the relationship between the venture and its employees. These documents specify terms such as job responsibilities, job title, salary, benefits, and termination conditions. A well-drafted employment agreement for a non-at-will employee can mitigate misunderstandings and foster a transparent working environment. Offer letters, on the other hand, provide prospective employees with an outline of the terms of employment. They often include information on job titles, starting date, and compensation, together with any conditions that must be satisfied before the commencement of employment. Both documents should comply with federal and state employment laws to avoid potential unforeseen legal problems. For ventures with multiple founders or investors forming a corporation, but not an LLC, a shareholders agreement is indispensable. This document governs the relationship between the shareholders and outlines their rights, responsibilities, and obligations. It is particularly useful to address aspects such as voting rights, buy-sell provisions, dividend distribution, drag-along rights, and procedures for transferring, selling, or purchasing shares. A robust shareholders agreement can prevent conflicts by providing a clear roadmap for decision-making and dispute resolution. It can also include clauses that protect minority shareholders, ensuring that their interests are considered in major corporate decisions. Crafting this agreement with precision is vital for maintaining harmony among stakeholders. The bylaws of a corporation serve as an internal manual for the company's governance. These rules dictate how the corporation will be managed, address issues such as board meetings, quorum requirements, and the election of directors, and generally provide for the day-to-day operation of the venture. Bylaws, when drafted correctly and followed consistently, provide a framework for decision-making and help ensure that the corporation operates smoothly. While not filed with the state, bylaws are a critical component of a corporation's internal structure and must align with the Articles of Incorporation. They provide clarity on procedural matters and can include provisions for amending the bylaws themselves as the company evolves. In fact, it's very important that those provisions be included. Consulting with legal professionals to draft or review these documents can provide invaluable peace of mind and ensure compliance with applicable laws. By prioritizing legal preparedness, startups can focus on innovation and best position themselves for future sale, IPO, or divestiture. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding the information in this video or the content of any of my earlier productions, please visit my firm website at www.cummings.law to schedule a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.